Good morning and welcome to Legal Notes Radio Show with Marianne, Charron, and Ned Barron. They are estate planning and probate attorneys. I'm Gary Byron. Glad to have you guys on board. Good morning, guys. How have you been?
Morning, Gary.
Good morning.
How was your week?
Busy as always, yeah.
It was good. It was busy.
I would imagine it is busy. What do they say? There's a couple of guarantees in life, right? Death and taxes, right? Is that what that's kind of businesses that are recession-proof as well, right? No matter how things are going.
So, yeah.
I think what we were last week, we were talking about conservatorships and DNRs, and we were talking about different types of conservators, court procedures, and so on and so forth. We actually had a question from the mailbag, if you don't mind me going right to that. And by the way, folks, I will give you an email address at the end of the show on how you can submit your question to be answered right here on these very airwaves, perhaps next week or soon thereafter. This comes from Sue, and she is in Canton, and she asks, what are the duties of a conservator? The duties of, well, because we were talking about that last week, so it makes perfect sense. She wants to know what the duties of a conservator are.
Well, as we talked about last week, there are two types of conservatorships. One is conservator person, and the other one is conservator of estate. So for a conservator person, your main duties are to make medical decisions for that individual who is incapacitated, the person that you've been appointed by the court to have the legal authority to make those decisions. So typically in that case, that you would be communicating with that conserved person's medical providers, and you would be making decisions about what the course of treatment should be, and giving informed consent for that, whether it was a course of treatment or it was a surgery or something like that. One thing to keep in mind with that, and this is overall with all conservatorships, either whether it's conservator person or conservator of estate, is that we are required, if we're a conservator, to use the least restrictive means, which means to the extent that that person can make decisions for themselves, that you want them to make those decisions. So, for example, when it comes to medical decisions, that you want that person to be involved to the extent that they can be involved in that in that conversation with their physician, sure, and also with that decision making. And so you're there oftentimes, a conservator is there oftentimes as to oversee that process and to make sure that that person is making good choices. For example, if a doctor said, you have diabetes and I want you to take this medication for the diabetes, and if the person says, yes, I'll take them, and they take those, then they are making that decision themselves. If the doctor says you have diabetes and you need to take this medication, and they say, well, no, I don't want to take that medication, then that a discussion ensues, right? That's where you might have to step in as the conservator to help them, to help convince them to make that the correct decision.
Yeah. So getting to Sue's question in terms of what are the duties and responsibilities, right? So there actually is, instructions that the probate court issues as to what conservators' roles and responsibilities are, and we have to follow that. But it's really, really important what Ned was saying in terms of the least restrictive means and how you always have to attempt to include the person in the decision making. So if you have melanoma, that, for example, so we're talking about healthcare decisions right now, a tumor has been discovered, they have melanoma, something you want to say, okay, well, this course of treatment is going to mean that you have chemo or radiation or something that is not very fun. To the extent that you can talk to that person, right, and say, what do you think we should do here? What's going on? This is, both Ned and I have had to accompany people to doctor's appointments. When we have had to be in that capacity, we're there. We're asking the questions of the doctor because we, always answer to the probate court. You talked at the last time that we were here last Saturday about family members, right? We're the ones going to the doctor's appointment, not the family members. You have to report back to them and try to be able to make sure that they understand what their parents undergoing, going through. And, we talked about that fine line. It can be a fine line. So
it just makes it that much more, I don't want to say the word rough or tough to understand if you're one of their children, but you're there representing the individual who is incapacitated.
Yeah.
You're looking out for their best interest.
Mm-hmm. Yeah.
Not necessarily that of their children.
Yeah.
Is that a fair assessment?
That's very fair, because when we are acting in the role as the conservator, we are standing in their shoes. Not their children's shoes. We're standing in their shoes. So...
and let's face it, that's a conversation that they had with you, not necessarily their children. Although they could have maybe touched upon, when it's my time to, to go, or if I ever become. They may have only touched the surface with them. It's an awkward conversation to have. I understand that, but that's why you exist. This is why you do this for a living. That they would have a much more comprehensive conversation about this particular topic with you. So therefore, every nook and cranny of what they're looking for at that point in their life, right? Where their children may only know surface stuff.
Well, I think one of the issues is that most of us, if we haven't gone through this process with a parent or a grandparent or somebody else, that we have no clue what that looks like. But Marianne and I, we spend a lot of time with our estate planning clients to talk to them about what the potential issues that could occur in the future, or that may be likely to occur. For example, the fact that the statistics show that 68% of us at some point during our lifetimes will have some period of incapacity, whether it's temporary or it's permanent. And so incapacity is one of the things that we speak a lot with our clients on, that what do you want to have happen in the event that you cannot make decisions for yourself? And so that's where documents such as financial powers of attorney or healthcare powers of attorney come into play. The living will, where you are planning today for something that may very well happen in the future.
Yeah.
What is the difference between a living will and a living trust?
Well, a lot. Okay, so a living will addresses circumstances when you are dying, right? So you no longer have, you're in permanently unconscious, persistent vegetative state. You show no behavioral responses to your environment, and your doctor says you are dying. That's what a living will is for.
Okay.
A living trust is a document that you create while you're living, and it's where you put your assets and you manage your assets, right? So they are very, very different documents. They do incredibly different things. And a living trust in no way really addresses, if you want to be put on life support or not. Okay. So that's what.
But interestingly, the parallel between the question regarding conservatorships and the two different types, conservator of estate, which deals with financial issues, and conservator person, that those documents kind of fall in those same categories.
Yes.
That the living will falls under the medical decision making, and the
financial,
the living trust falls under the financial. Because one of the really nice things about revocable living trusts is, and it's a document that is typically put in place to take the place of a will. And so one of the primary reasons why people do revocable living trusts is to avoid probate. Because if at your death, your assets that would otherwise be probate assets, and a probate asset is a solely owned asset with no beneficiary designation on it. At your death, if you have a solely owned asset, like if I pass away and I have a bank account that's solely in my name, nobody has the legal authority to do anything with that. Well, the same thing with that bank account is that if I don't have any documents in place and I become incapacitated, nobody has any authority to do anything with that account. And so that's where a conservator would come into play. With a revocable living trust, not only can it help you to avoid probate and to distribute your assets at your death according to what your wishes were, but also in incapacity that you will have named someone who is called a successor trustee to step into your shoes and to manage your trust assets for you during your period of incapacity, whether it's temporary or permanent. If it's temporary, once it's been resolved and you regain capacity, that successor trustee can step out and you can get back to managing your own assets.
Do you create a living trust as well as in your practice?
Oh, yeah.
Absolutely.
We do it a lot. Mm-hmm.
What would happen if somebody passed away without having a will ever made up?
Well, you go to probate court, right? So the term is called intestacy. You die intestate. I'm not saying that's a good or bad thing, but so if you don't have a will, then someone, presumably a family member, is going to go to the probate court and file an application to have your assets probated. In other words, distributed to who your heirs at law would be. And there is a very specific statute that will decide who gets your stuff in the event you didn't create a will. And so you have to follow along with the statute. So, for example, if you're married and you have no children and your parents are also not alive, then everything's going to go to your spouse. All right? But what's really important is to understand what is a probate asset and what's non-probate assets. I don't know if we really want to. Do you want to get into that? Probate versus non-probate? You started it a little bit.
Sure. I think it's a really important concept for anybody to understand, because probate courts generally, when we talk about probate assets, again, the definition is a solely owned asset with no beneficiary designation. And I gave the example of if I have a bank account that's solely in my name and there's no named beneficiary on it, then at my death, no one has legal authority to do anything with that. And that's where the probate courts come into play. And but sometimes it's easier to talk about what's a non-probate asset. And a non-probate asset would be a life insurance policy. If at the death of the person whose life was insured, that the named beneficiaries under that life insurance policy are living, then they go directly to the life insurance company to make their claim. So they have that legal authority to go directly to the life insurance company. Same thing with retirement accounts. As long as those named beneficiaries are living, they go directly to the financial institution that's managing that retirement account to make their claim. So there's no need for probate court intervention because they're not probate assets. Somebody has the legal authority to access those assets. Same thing with a jointly owned account. In Connecticut, the legal presumption is that at the death of one co-owner of an account, that the surviving co-owner is now the 100% owner of that account. There are some exceptions.
Yeah.
But
we had to litigate
general,
them.
Right.
Yes.
Of course.
That's right.
I've heard where somebody would say, you better have a will, otherwise the state takes it all. Is that a rumor? Is that a myth? Or is there any truth to that?
Both. I mean, it depends on if you ever received state assistance during your lifetime. So if you or your children had Husky benefits or you received any type of benefits from the state, then at your death, the state has a lien, has a claim, and the state they're the first priority lien holder after your funeral expenses are paid. And the state would be repaid for having given you that benefit. Also, if you've ever been incarcerated, there is such thing as an incarceration lien. So if you have a family member who was incarcerated for whether it's a short or long period of time, the state of Connecticut has a lien for your room and board, so to speak, when you were incarcerated. And so the state would also be entitled to be repaid that.
Really?
So,
good.
So anyways, there are circumstances. One of the things, if you don't mind, I just wanted, Ned, when you were talking about probate versus non-probate assets, one of the things that both of us have come up against is that people seem to think that if they create a will, then the will is what prevails in rules regarding all of their assets. And Ned was just talking about beneficiary designation assets and assets that might have been jointly owned. And so, for example, one of the things that I talk about with clients is, okay, so let's say you come to me and you have previously been married, all right? And you're married now to your second spouse, but you never changed your life insurance beneficiary, and it still names your former wife. Okay? Ned was just talking about non-probate assets. So that even though in your will you say to me, I want to leave everything to my loving spouse, and in your will you say, I give her everything. But if your former wife is still the beneficiary on your life insurance policy, what you designate as a beneficiary trumps whatever is in your will. Okay? That's why it's a non-probate asset.
I see.
So your ex is going to get the life insurance policy and your wife is not going to get your life insurance policy. So that distinction that Ned was talking about is really, really important.
Well, there's other circumstances that can be kind of awkward as well, where, let's say, I pass away and leave everything to my wife remarries, and my former assets now become theirs. And let's say now they divorce. Can my assets then become his? Or let's say I leave it to my son, and my son inherits it, and I have it well documented, and then my son gets married, and then he gets a divorce. Could his ex now receive something that was originally mine? Do you get what I'm saying?
Oh,
now,
yes.
How does that go back to the living trust that I referred to a moment ago, or
it can and should, right?
Yeah.
Go ahead.
When we are doing estate planning for clients who have blended families, so you're talking about remarriage and all that. One of the things that we do talk about is, how do you want your assets to be distributed if you're still both married? And let's say you have, and it can get very complex, but if you have now blended family, let's say both parents were previously married, now they have kids from their first marriage, they have kids from the second marriage.
Oh.
It gets really complicated about, well, then how do we divide up the assets? It gets really complicated. So that's part of the discussion that we have with our clients. Really, the question is what do you want to have done with your assets? And if it's to protect them, as you're talking about, from from the, subsequent marriage, or for children who are to inherit something in the future, and you're worried about protecting those assets from their spouse, that there are a couple of ways. We build into our documents some what we call special distribution provisions to prevent, if that issue was happening at that time, right, that divorcing, your child's getting divorced at the time of your death, there is a way to protect assets at that point. However, if you really are concerned about it, then what you can do is, instead of giving those funds directly to your child, that you can create a trust for them. And so that what they would inherit would go into a trust for their benefit, which could then be protected from divorcing spouses in the future, from creditors, from, if they became disabled, they could protect assets for them in that instance.
And you also can create a trust for your surviving spouse. And one of the things that you could address in there was that if he or she remarried, so a subsequent marriage after you passed away, that there would be a prenup. So in other words, to protect those assets so that at your spouse's death, they would then go to your children, as opposed to then becoming an asset that would be divisible or then glommed onto by the new spouse. So there are ways, you really touched upon the importance of trusts, and the way of making sure that the money goes to who you want it to go to. But you can get as creative as your life circumstances. Okay.
Folks, you are listening to Legal Notes Radio Show. We have estate planning and probate attorneys, Marianne Charron, and also Ned Barron. I'm Gary Byron. What if you've got no spouse, no kids? I guess let's just say I would automatically think it would go to parents. But let's say your parents aren't around either.
Yeah.
Well, what? I mean, there's got to be people who've got very little or no family. I mean, what happens then?
If you are single and you pass away with no children and no parents, then and no will, right? If you have a will,
well, yeah, then it's
right. If you have a will, then it goes by what you determine in your will. But if you have no will, then there is a I call it a pecking order, about who would then, your heirs at law are what the correct term would be the ones that inherit from you. And so it would look for your closest living relatives. And it kind of picture a family tree. And you're kind of at the bottom of the family tree.
Okay.
And at your death, the law would look to that family tree and go up the family tree, look for living parents. And if you had living parents, then your parents would inherit from you. If your parents were predeceased, then it would look for siblings. And let's say, for example, you had 3 siblings, and and say they were all living, so each one would get 1/3 of your estate.
Okay.
However, if one of those 3 had predeceased you, but they had children, then their share would then go down to their children. So again, you kind of go up the family tree and then sprinkle down until you find the most closest living relatives.
I've got a scenario for you.
He's grinning. This is not going to be good.
Listen, nothing that I'm sure you haven't come across.
Probably.
What if you have children out of wedlock?
Mm-hmm. Sure. So they're still your kids.
Oh, right.
So, either hopefully you've explained this to your spouse. So it may come as a shock when your child shows up when at the probate court hearing was like, hi. And I've had that before.
Have you really? I told you.
I have. I've actually had to do paternity trials when someone shows up and says, hi, I'm his kid and I'm entitled to my share. If the child is biologically yours, so if you signed their birth certificate or it's been found by a paternity test to be your child, then your child gets a share. And so if there are 2 other children who are, I'll say, legally legitimized, and this child has yet to be legitimized, okay, then that child gets 1/3 of your estate. So it doesn't matter if the child is legitimate or illegitimate, to use the legal terms. I realize those are probably not very nice terms to use, but they take.
I presume makes no difference if your children are adopted neither, right?
Well, with adoption, that child that you adopted is treated as if they were your natural child. Right.
That's what I was thinking about.
One circumstance that we address when we do wills, so there could very well be children who, let's say you marry someone who had children very young. You've never adopted them, but you treat them as your own children and have always treated them as your own children. That happens fairly frequently. If you die without a will, those kids wouldn't get anything. Okay? Only your legitimate children or your adopted, your legal children would get it. And so we can, in our documents that we draft, we can put a clause in there that says, I want to treat all of these children as if they were my legal children, and you would include stepchildren, for example. But otherwise, those children would not take.
Although one of the really interesting things about the probate court, and there are a lot of fascinating things, is that there is such a thing as called an adult adoption. And we as adults we can petition the probate court to allow us to adopt an adult. And I've been involved in
like a special needs adult, or somebody who
it could be anyone with
you don't have to have
you don't have to have
needs.
special needs. I had a case quite a few years ago where this husband and wife had a business, and they had taken this young man, he was 17 when he started working for them, and they really took to him. His family was, not in great shape, and he lived a really rough life. So they took him under his wing, and in practice, they were treating him like their son. And they finally said, you know what? We want to make this legal. We want to recognize him as our child. And so he was 27 at the time. And we had a probate court hearing, and the judge approved it. And it was interesting. The grandmother showed up. A couple of cousins showed up. It was a real family affair. And it was really emotional to see that these people who had, no blood ties to this young man wanted so much for them to be their son, that, and now that he was an adult, which we probably think an adult adoption, does sound kind of odd.
Yeah, of course.
But it is, in fact, something that we can do. And it was really beautiful to see them doing that this family now became, this whole family with an adult.
We were talking earlier, I know we're running out of time, but we were talking earlier about, what happens if you don't have a will. I would think like somebody in their 20s, it's the last thing that's on their mind. We're talking about being immortal, right? Where you probably get, for those individuals who don't have wills, it's predominantly, I would think, people in their 20s, right? Not married, single, and young.
We have plenty of families who have never done a will before. Plenty.
Of all ages.
All ages. Certainly young people, they're like, what do I even have other than student loans? So sometimes, I don't know if, I'm sure, Ned, you've done this, is that we have the parents who come to us and they're like, hey, can you do documents for our kids too? And, we just kind of, because someone's going to have to make a decision. They're an adult, they're over 18, and the parent wants to be able to make financial decisions and healthcare decisions if something does happen to the child. So we don't have, there's certainly not a lot of young people, but I would have to say we have plenty of people from all ages who come to us and have never had a will before.
Oh.
So.
Yeah, that's, and again, it's something that people really need of all ages. I mean, you think about unforeseen circumstances, vehicular, incidents. That's just, no one ever plans for. Folks, again, you've been watching, well, I've been listening to Legal Notes radio show, unless you're watching it, and you have to clue us in on that secret. Check them out at their website. This is where I tell people always start first, on their website, www.charteroaklaw.com. Once again, charteroaklaw.com. I always say to start there because a lot of times your questions can be answered via the website, but it also may spark even more questions that you may perhaps have already written down. If you have, and you've already poked around on their website, give them a phone call, 860-570-1229. Once again, 860-570-1229. If you got a question you'd like to have answered on this show, legalnotes@charteroaklaw.com. That's where you should email. For Mary Ann Charron and Ned Barron, I'm Gary Byron. Thanks so much for listening. We'll talk to you next Saturday. Have a good one, everybody. So long.